Good morning, good evening, good afternoon. I saw this particular video come across my feed, recommended. I don't subscribe, obviously, to Carolina. Comedy court. Dumbest DA in history. Hearsay is inadmissible in court. Devil face, hashtag prosecutor incompetence. And I thought to myself, if I want to learn the law, I'll go watch Carolina in Fort Worth, because obviously she's a legal genius. But I thought, you know what? Let's hear it. Let's figure it out. Just for the record, there are a lot of judges who stream their hearings across the United States. This particular judge, Judge McNally, out of District 33 in Minnesota, he does live stream his hearings through the court, and he just doesn't save the live streams. So, I mean, if you're interested in watching his stuff, you got to watch it when it's fresh, or else record it somehow, because he doesn't save his live streams. So, but he does have his own YouTube channel. So I'm not really worried about getting copyright struck by this. She just added her own canned bullcrap visuals to some of it. And I'm sure that countless other internet YouTube content creators have also broadcast this particular hearing. Whose is it? Well, it's Judge McNally's. It's the 33rd District's, and I doubt they're going to copyright strike me. So, anyway, let's see what Carolina has to say.
They're idiots. It's also the prosecutors, the guys we pay six figures to put bad guys in jail. A guy who attended the university for 7 years to become a prosecutor.
Well, university for 4 years and then law school for 3. Generally speaking, you can get the law school done in 2, and you could also probably get university done in less than 4.
Let me prove that to you. This is the Woodhaven.
So she's going to prove that prosecutors are dumb by showing one prosecutor who lost a probable cause hearing? Okay.
District in Michigan.
And I'm just wondering, what does it mean when prosecutors win? Does that mean the defense attorneys are dumb? Or sometimes does the evidence actually support what the prosecutor is saying? Sometimes maybe the defendant actually is a criminal. Maybe the defendant actually did a crime. There's only so much a lawyer can do. The lawyer can essentially try to repack facts, give a different narrative for the facts, package up all the known facts into a different storyline. But sometimes they're just facts that you just can't deal with. I mean, they're just incriminating. And at that point, you just try to plea bargain.
The Honorable Michael McNeely's courtroom. And here we have a hearing to determine if the cop even had.
And see, already out of the gate, we're 25 seconds in. She says this is a reasonable suspicion hearing. This is not. This is a probable cause hearing. Normally, after you're arrested, the court will do a probable cause hearing. It's the first opportunity the defense attorney has. I mean, maybe not in all jurisdictions, but in California, they'll have a probable cause hearing. And the probable cause hearing is the first opportunity that the defense attorney has to see what kind of evidence the prosecution has. It is an opportunity to cross-examine witnesses, at least in some jurisdictions, maybe not in all. And it's where the judge determines whether or not there's probable cause. And probable cause is different than reasonable suspicion. Reasonable suspicion is where the cop believes crime is afoot. He thinks that crime is likely afoot and you likely did it. It's a lower bar than probable cause. Probable cause is where a crime was probably committed and you probably did it, which is a lower standard than preponderance of the evidence or clear and convincing evidence or beyond a reasonable doubt. Reasonable suspicion is the lowest level, and that gives the officer the ability to detain you and do a Terry frisk, pat you down for weapons if there's reasonable suspicion that you're carrying in commission of a crime. Probable cause is then what he has to develop in order to lawfully arrest you. And it's also the standard that the prosecution needs to prove to the court to prosecute you. And then, generally speaking, in a criminal matter, the next issue that is heard is the trial, where the prosecutor has to prove beyond a reasonable doubt, which is a very high standard of evidence, higher than I think most juries understand. And that's what's required to convict you. So this has nothing to do with reasonable suspicion. She's completely out over her skis. She doesn't know what she's talking about, and she's just making an ass out of herself. So congratulations, 25 seconds in, and you're already wrong. Good job, Carolina, whatever.
Reasonable, articulable suspicion of a crime in the first place. So this, of course, is a judge. And this is
Thank God she told us who the judge was. I never would have figured out who the judge was. I mean, the guy in the black robes, really? That's the judge? How did she figure that out? Because it says Honorable Michael K. McNally. I guess.
is Mohammed, the prosecutor, trying to put the defendant, Sergio Bello, in jail. And this
At this point, he's trying to get the court to agree that there's probable cause so that they can proceed towards trial, wherein a jury, since I believe he's being charged with at least one felony, maybe more, where a jury, most likely, maybe a judge, would be the one to determine whether or not he's going to go to jail. And this most likely assistant DA, probably not the actual county DA, but probably an assistant DA, might not even be the attorney who does the case. Oftentimes they're not, in my experience. Different jurisdictions can do things differently, but oftentimes not.
is his lawyer, Lily DeLallo, the person that saves the day.
But does she really save the day? I mean, does she really?
Let's get into it.
Because remember, this is going to be about hearsay, and her hearsay objections are going to save the day.
Oh, and one more thing. One of the first things that a prosecutor learns in law school is that they cannot use hearsay in the court.
You're not a prosecutor in law school. That's another stupid thing. You're a law student, and after law school is where you decide what field, what practice of law you want to go into. Some people decide to join the prosecutor's office, join the DA's office, and become prosecutors. Some people decide to join the public defenders and become defense attorneys for criminal matters. Some guys go into family law. So, and it's, was evidence a first year? I want to say actually evidence, which hearsay is evidence. I want to say that evidence was second year. Second, it was either, yeah, I think it was second year. First year we did crim law and crim procedure, but I think evidence was second year. I mean, your mileage may vary, your law school may be different than my law school, but it's not one of the first things you learn in law school. That's also dumb. She doesn't know what she's talking about, so.
Courtroom. It's inadmissible. And
It's not inadmissible. It may be inadmissible. First of all, depending on what jurisdiction you're in, there's a litany of exceptions to the hearsay rule. A litany of them. If the declarant is unavailable and was made unavailable by the opposing party. So, statements by opposing parties. Statements that don't go towards the fact of the assertion, but just that the assertion was made. Statements that represent the mindset of the declarant, excited utterances, statements by a party opponent. I mean, there's a long business records. There's a litany of exceptions to hearsay. And another thing is that once you've been practicing law for a while, Carolina, which you probably don't know since you don't practice law, is that sometimes you ask questions to which there is a valid objection, because unless the valid objection is made, it gets in. The opposing counsel has to make a valid objection, a timely valid objection to it, or else it's in. So, oftentimes, in my experience, lawyers will ask leading questions or argumentative questions or hearsay questions, anticipating that the other side might not get their objection in before the answer is made, or might not object at all. especially during a long trial. You get worn down. Maybe your client decides to talk to you when the question is asked. Oh, by the way, don't these two people on the screen, don't they really add to hearsay? I mean, they really explain what hearsay is. But as trials go on, more and more questionable, like later in the day, more and more questionable things get through. So just because it's hearsay doesn't mean you don't ask it. So that's also stupid. Like, oh, sure, it's inadmissible, but it's only inadmissible in some situations. First, it has to be objected to. And second, there has to be no exception to the hearsay rule for it. So again, your mileage may vary.
No hearsay is you can't use what somebody told somebody else. That's
Well, see that even her statement there is wrong. There's a couple different definitions of hearsay depending on what jurisdiction you're in, but essentially, it's an out-of-court statement where the declarant is not available in court to testify about it, that is offered for the truth of the matter asserted therein. That's a general, I mean, again, different jurisdictions have different flavors of that basic statement, but it's an out-of-court statement where the declarant is not in court to testify to it, and it's offered for the truth of the matter asserted therein. So, like, let's say you're offering it for the effect on the listener. That's still an out-of-court statement. But if you're offering it for the effect on the listener, the effect on the hearer, like let's say it's a case where you're accused of trampling someone to death. You run over them on your way out of a crowded theater, and the question is asked to you, well, why did you run out of the theater? Well, I heard someone yell fire. Okay, well, that's an out-of-court statement. And it's not offered for the truth of the matter asserted, because there may or may not have been a fire. It's offered because that explains the effect on the listener, the effect on the person who decided to run out of the building and ended up trampling someone. So you can see her explanation of what hearsay is completely lacking. It's a very nuanced topic, and if I remember correctly, we spent like a month on hearsay. I mean, we spent a long time on hearsay because there's so many exceptions to it, and there's so many nuanced things. Like there's double hearsay, and sometimes you could have like one layer of the hearsay have an exception to it, but another layer not have an exception to it. It just gets crazy.
so simple. But wait till you
It's so simple, she says, because she has no idea what she's talking about. It's so simple, but it's not so simple. I've already explained it, that just because you know that there's a valid objection to your question doesn't mean you don't ask it. The definition she gave for hearsay is not what she gave. My definition, what lawyers understand as hearsay, is not what she gave. And there are tons of exceptions to the hearsay rule. Tons of it. So, not so simple. Only if you're stupid. Only if you think in like little binaries, like she does.
see how dumb this prosecutor that we pay six figures to is.
All right, so he's going to be dumb. He's going to be dumb, in my estimation, if he fails to get the guy bound over for any reason at all. Because, in my experience, prosecutors tend to throw a lot of charges out, hoping that some of them will stick. They tend to overcharge. So, as long as he gets the guy for something, there you go. So let's see by the end of this if the defendant is bound over.
Any other preliminary matters? Mr. Mohammed?
No, not from the people.
Ms. Diallo?
None, thank you.
Thank you. Call your first witness.
People call Officer Gregory Brewster.
Okay. Officer, stand up, please. Raise your right hand.
I'm also going to guess, because this guy is doing like the probation, or not probation, the probable cause hearings, that he's probably not high up on the totem pole. He may not have been practicing law long. He may have only been practicing probably for a couple of years. He looks young. So, it takes a while to kind of get in the swing of things as an attorney It takes a lot of court time to get in the swing of making objections and things like that.
You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
I do.
Okay.
That's interesting. Normally, in my experience, the clerk swears people in. It's rare that the judge does it if there's a clerk available, so that's interesting.
It's Gregory,
Yes, sir.
Brewster.
Yes, sir.
Okay, Mr. Muhammad, you can proceed.
Thank you. Good afternoon, Officer Brewster. Can you please restate your name for the record?
Look how young this guy looks. He's a young dude.
Lieutenant Brewster, Trenton Police Department. Okay, Lieutenant Brewster, are
And he's going down a checklist, by the way.
you currently employed?
Yes,
Who is your employer?
Trenton Police Department.
And in what capacity are you employed there?
I'm a patrol lieutenant for the police department.
Okay, and were you
For those of you who are listening to me on a faster speed, nope, I'm not going to change the speed because for some reason I can't. Oh well, we're listening to it. They took away my speed adjustments. Oh well, I guess we're listening to it on one-time speed because I'm not paying for premium.
employed in that capacity as a patrol lieutenant on January 26, 2023?
No, I was a patrol sergeant.
Okay, and on that day, did you work?
Yes,
On that day of January 26, 2023, did your duties as a police officer take you at or near the location of 1875 West Road?
yes,
Is that located in the city of Trenton, county of Wayne?
yes.
What took you to that location?
I was there for an unwanted subject.
Okay, and what is at that location?
It's at a gas station.
Okay, and upon making that location, what did you do, if anything?
I made contact with the clerk who called.
Okay, and what did you learn?
Oh, I'm gonna object this to hearsay.
Any response?
Judge, I didn't ask about any specific statement. I'm just asking the officer what you learned since his
At
investigation.
least it's overbroad, sustained, rephrase. Is this
So the judge substituted a different objection because he's probably looking for the effect on the cop at this point, because just so everybody's aware, I believe there's like a obstructing charge and a eluding charge. I believe that those are the two that are at stake, something along those lines. So neither of which is the clerk's testimony relevant to. What the clerk told the officer, he's not using that to establish reasonable suspicion of either one of these things. This is just what he learns in his investigation. The effect on the listener, it led me to believe that this person might be the issue, so I wanted to talk to him.
is this the gas station on the corner of Fort and West?
Yes, sir, it's Kings Mobile.
Thank you.
Okay, so sir, you indicated you had contact with the clerk?
Correct.
Okay,
This is probably over here the gentleman with the beard and the black shirt, gray suit. He is probably a senior prosecutor. So this young man might still be on probation, basically, during doing his training. That's what they use these guys for, in my experience. I don't know how they do it in Minnesota, but this guy right here in the black shirt is probably a senior assistant district attorney who is just there to make sure that the trainee, the probationary, the new assistant district attorney has someone to ask questions to if he needs to.
okay, why did you have contact with the clerk?
That was the call.
Okay, and after having contact with that clerk, did it have any effect on you?
Oh, look, now he's looking for the effect on the listener.
Did it cause you to make your next decision?
Yes,
Okay, Your Honor, at this time, I think the statements by the clerk would come in under effect on the listener. The officer indicated.
Well, ask your next question. She can object
Yeah, boy. Yeah. So this guy's young.
if she wants.
Okay. Officer, what did you learn from the clerk that caused you to further your investigation?
Wait 1 second.
So Judge, I am gonna object to hearsay. So I think the way we might do this is based on what you learned from the clerk. did you do something as opposed to her words
Assisting,
sometimes?
assisting.
Okay, officer, based off of what you learned from the clerk,
So again, nothing that he learned from the clerk has any bearing on the criminal actions allegedly taken by the defendant. Absolutely nothing.
did you do something based off of those statements?
Yes.
Okay, what were the statements that that had an effect on you and caused you to change your steps?
She told me.
Wait,
that-
no, that's hearsay. I object.
Sustained.
Thank you.
I'll just move.
What did you do next, sir? After speaking with the clerk, what did you do next?
I made contact with the person that the clerk called,
And where was that individual located?
standing next to a vehicle near the gas pumps.
Okay,
So the judge helped him out there, got the testimony moving. Again, this guy's young.
I could still do this, Ms. Diallo. 31 years later, I could,
How many?
31. Believe it or not.
Look at
Go
this
ahead.
poor judge having to deal with Mohammed.
No, this judge is having to deal with your basic Thursday afternoon. You know, the judge does not care about Muhammad. It's not bothering him.
Mohammed. How does this guy not know what hearsay is?
I think the judge might be more wanting to get to the point of it. He's trying to get past the preliminary matters that attorneys have to establish to get to the heart of the matter, to the actual probable cause for a specific crime. I think that's what he's trying to do. He's just trying to move it along.
okay, and the individual you made contact, where was he standing exactly?
Next to the vehicle.
Okay, can you describe the vehicle?
It's a red Fusion.
Okay, and was there anybody that was sitting
Yeah, that judge doesn't look annoyed.
in that vehicle?
No.
Okay, was there anybody else besides that individual standing outside of that vehicle?
No.
Okay, now that individual that was standing right outside of that, was it a Ford Fusion?
Yeah.
Standing outside of that Ford Fusion, do you see that individual in the courtroom today?
Yes.
Can you please point to that individual and point out an article of clothing that individual's wearing?
Oh, by the way, Ford Fusion, excellent car. A little bit big for my taste. I prefer the Fiesta, but this young man, the defendant, has excellent taste in motor vehicles.
A black suit coat.
Your Honor, please let the record reflect the witness has identified him.
Record should so reflect.
Thank you. And did you initiate contact with that individual that you just identified when you were at the scene on that day?
Yes.
How did that begin?
I don't remember my exact words, but I think I said, hey, what's going on? Or
Okay.
how's it going?
What happened next?
The radio in the car was very loud, and I believed it was gonna be difficult to have a conversation with the person. And I asked to turn the radio down. I said, can we turn the radio down? Something to that effect.
Okay, besides that, was there any other observations that you made?
When I first made contact with him, I noticed
And who's him, just for the record?
the defendant there.
Okay,
When I first made contact, I noticed that the person was unsteady on his feet and he had red eyes, red bloodshot eyes.
okay, and based on your training and experience as a police officer, what is that indicative of, if anything?
I believe that he was under the influence of something.
Okay, and so what happened next?
Against my better judgment, he sat in the car to, I believe, turned on the radio, but that's not what happened.
Okay, what happened next?
You say turn up
Turned
or
on
turn
the
up?
radio. Against my better judgment, he sat in the car to, I believe, turned on the radio, but
You
that's
turned
not
off the
what
radio.
Okay, what happened next?
the person attempted to put the vehicle in drive and
Oh, okay, before we get to that, where did that individual sit?
dressed.
Okay, at that point, was the vehicle on or off?
It was
Okay, and after that individual sat in the driver's seat, what happened next?
the person put his foot on the accelerator and tried to put the vehicle into gear.
How do you know that?
So I saw it.
Okay, and what happened next?
I told him to stop twice,
Okay,
very loud,
okay, and why did you tell him to stop?
because I believed he was trying to leave.
Okay, and when you told him stop the first time, did he say anything in response or do anything?
No,
Okay,
he continued to try to put the car in gear.
okay, and what about the second time? What happened after that?
Same thing. He continued his actions,
Okay, and what was his actions that you were observing?
that he was trying to put the vehicle in drive.
Okay, what happened next?
The vehicle got into drive and the driver of the vehicle left.
Okay, and the driver of the vehicle, just, I wanna confirm for the record, that's the same individual you identified here in court?
Correct.
Okay, and what happened after that?
The vehicle drove east towards one of the entrances / exits to the, gas station onto Fort Street.
Okay, and do you recall what the posted speed limit is on Fourth Street?
On Fort Street, it's 50 miles per hour.
Okay, and based off of your observations, what did you do?
My vehicle was parked on the opposite side of the gas station. So I ran back to my vehicle, got my vehicle.
So just so I know, you were on the west side of the building? Is that where you were?
My vehicle was parked on the west side of the building. I walked into the gas station and then I walked out.
So now when you were confronting him, you were on the east side of the building?
Correct.
He pulled out and started traveling southbound on Fort?
No, northbound.
Northbound, okay.
And you indicated that the posted speed limit in that vicinity is 50 miles per hour?
On Fort Street, M85, correct.
Okay, and what did you do next?
I ran back to my patrol vehicle to get in and attempt to pursue.
Did you attempt to pursue him?
I never turned my lights on. I thought I saw the vehicle turning north onto now the northbound lanes. So my assumption was that the vehicle went.
You may object to the speculation.
Okay, so you can testify, and I'll keep on record that portion up to my assumption was.
Okay,
All the rest is strict, that language is stricken. You can ask your next question.
I would agree that it is. And so what did you do after that?
I saw a vehicle turning from eastbound West Road to northbound Fort Street. I believed that vehicle was the vehicle that I was after, because I saw taillights of that vehicle turning. So I drove south on the Fort Street to the turnaround to try to catch back up to it, to go back northbound and catch up to that vehicle.
Okay,
There's a no left turn signal there, is there not?
Yes,
So in order to turn from eastbound West Road on the northbound Fort, he had to disregard that signal, correct?
yes, sir.
And you turned back southbound on Fort, did the Michigan turn, and now we're heading back northbound on Fort.
Yes, sir.
okay, and were you able to locate that individual, the defendant?
No,
Okay, and so did you learn anything else pursuant to your investigation?
I returned to the gas station and spoke to the clerk.
Okay, and what did you learn?
Oh, no, I would object just to hearsay, anything she said. Thank you.
I learned that
Wait a minute,
What's
slow
going
down,
on?
slow down.
Judge, I'm not asking for a specific statement, so there's no specific out-of-court statement. I'm just asking also what you learned pursuant to this investigation.
That was a dumb justification.
Any response to that?
I think you can ask, and this is just me, I don't know, it's up to the judge. Based on your investigation, what did you do next without saying the specific words? Because we know hearsay is a statement offered by the declarant, other than while testifying at the trial or hearing, offered to prove the truth of the matter asserted.
Wow.
And that sounds suspiciously like the definition that I gave.
I've been 30 years too, Judge.
So you have an attorney who's been practicing 30 years against someone who's probably brand new. You know,
Go ahead,
I would
Mr.
agree.
Muhammad.
Officer, based on your investigation, what else did you discover based on your interaction with the clerk?
I learned that I went the wrong way and was pursuing the wrong vehicle.
Okay, and did you learn the correct way that the individual fled from the scene?
I learned that the vehicle went,
Where's her objections to hearsay there? Because he's saying what he learned from the clerk, which is still hearsay.
I saw the vehicle turn north onto southbound Ford Street, but I learned that it did not go that way. It went west on West Road.
Wouldn't that be hearsay, Judge?
Oh, she's objecting. She's objecting after the answer was given. That's late. Let's see if the judge allows it.
You learn, because you have to learn it through hearsay. So I would ask that that be strict and objection hearsay. Can't speculation.
And Judge, I would disagree. I think there's no specific out-of-court statement that's being offered. I think the officer is just testifying to what he learned pursuant to his investigation. There isn't a specific out-of-court.
You have to bring it within an exception, or he'll argue it isn't hearsay.
Well, I guess my first argument is that it's not even hearsay because there's no statement. But if the court is implying that it is, then
Wait a minute, how's there no statement? If he learned after talking to her, no matter how you phrase it, he learned based on her statement, right?
he learned pursuant to his investigation that the individual
Young attorney.
had turned a different way. But hearsay is when we're introducing a specific statement. There isn't a specific statement that the officer is testifying to. He's not saying John Doe stated X, Y, and Z. He's just saying, I had a conversation.
It's still based on hearsay, no matter how you cut it. Otherwise, you could get around the hearsay rule every single time. Be like anybody asking anybody, what did you learn after speaking with them? That statement is still hearsay. I'm gonna find that it goes to the declarant's state of mind,
That's an exception.
and I'm gonna allow it.
Okay.
Understood. Thank you.
Ask your next question.
Did you learn based off of your discussion with the clerk, the street that the defendant had fled from? That the defendant had turned onto?
West Road.
Okay, and do you recall,
Where was the objection there? No hearsay objection there.
do you know what the posted speed limit is at that location on West Road?
35 miles per hour.
Okay, no further questions.
Did you ever apprehend the defendant?
Me? No.
So the judge is like, what? Okay.
Ask your next, any cross? You have cross?
Just 1 second, Judge, I'm thinking, right? real
Okay,
quick.
take your time.
Just one question.
Yes, ma'am.
You weren't sure at first who the person was because it could have been a host of people. Is that fair to say? Like, you said you thought it was the brother.
No.
Well, wait a minute, the brother
They must have cut out a lot of content on this because I have no idea what she's talking about with the brother.
name is one of the Blues, right?
Are you,
So you didn't know who the person was. Is it fair to say at first?
I did not know that.
I don't have any other question.
Mr. Mahan,
No further questions.
you can step down, call your next witness.
No further witnesses in the future.
So I'm wondering if this is the only witness he brought. Because I don't know.
You have no further witnesses. What are you gonna do?
Judge, I'm gonna motion for a bind over, I believe. Testimony reflects a question of fact, the trier fact, and I'm gonna reserve any rebuttal.
Any argument, Ms.
Oh, I
Diallo?
object to any bind over on these particular facts that were presented. We don't have identification. There are a whole host of things that are wrong with this matter. For probable cause, we object.
She doesn't identify any of them, and she's the hero. Like, we object. Oh wow, thanks. There's a whole host of issues with identification. So there must have been something else in identification that I'm not aware of, because the identification, as far as him being the guy who drove off without obeying the officer's commands, that was pretty well identified.
Mr. Muhammad?
Judge, in regards to identification, the officer indicated that he made contact with the defendant at the scene, and he identified his being that person here in court today. I think in-court identification is sufficient for probable cause. We're not here
Maybe she's meaning identification of the officer as a police officer.
determining guilt, just whether or not there's probable cause of a crime, and I believe we've established that on this record.
Anything else, Ms. Deanna?
No,
So there's another cut there. So again, I don't know what all we're missing.
Judge, you've heard the facts of this particular case. I think I don't know what happened out there, even by probable cause standards, but I believe the officer testifies the person that he thought was doing one thing wasn't doing what he thought. It was the wrong car. It's a mess. It's Judge. We don't think
It's a mess, Judge. Like, what is it? That's an argument? Okay.
there's probable cause at this stage.
We don't think there's probable cause. Her whole argument is we don't think there's probable cause. So they don't ever tell us about the eluding or whatever, but there's two Minnesota statutes, one in the vehicle code, one in the criminal code. They're both identical of the fact, other than one has a $2,000 penalty, max penalty for fourth degree, and one has a $500 penalty for fourth degree. But the language of the statutes is the same. It requires a uniformed officer in a uniformed car, if there's a car, not uniformed car, marked car. And that officer, if the officer gives hand signals or audible signals or lights and sirens, and you fail to stop, then you could get a fourth degree, or no, it could be a felony for up to 2 years, that eluding statute. And what I noticed in looking through the transcript while we were watching this was that the officer never testified he was in uniform. And he also testified that his car was on the other side of the building from where the defendant was. So the defendant didn't see a marked vehicle. If he called it a cruiser, so I'm going to assume that it was marked. But the prosecutor never elicited a statement about the officer being in uniform, like in a patrol uniform. So I think that's where they screwed up. I think that's where the prosecutor screwed up.
So for that, we would ask the court not to bind over.
But so she's made a couple hearsay exceptions to testimony that has nothing to do with the eluding statute. We'll get there. And she basically says, we object, and I don't think there's probable cause. I mean, if that's your idea of what good defense work is, okay.
And Judge, may I have a brief response? In regards to the R and O, the officer indicated that he was in full uniform and that he made
R and O is, I believe, resisting and obstructing.
contact with the defendant. He gave him 2 lawful commands, at least from what I recall, to stop, and the defendant did not stop. He then fled from that location. The officer he gave the defendant voice. The defendant was a driver of the vehicle, and he gave him voice signals to stop. The officer was in full uniform, and
I don't recall testimony that he was in a full uniform,
we also learned that
but that might have been cut out of this.
the defendant did not stop and willfully fled from this scene.
Or I might have missed it. Let's double check. Yeah, so he doesn't mention it till 1630 and 1656. And it's, yeah, so he did not elicit that testimony. And that's necessary testimony for probable cause on that eluding. Let me look up those statutes again. Let's go to history. Yeah, so it's this one right here. Subsection does not apply unless the officer giving the signal is in uniform. And there's also a case that says that the officer doesn't have to be in their vehicle. They can make the orders. It's People versus Green from 2004. But yeah, the officer does have to be in uniform, and he did not, at least in this, elicit testimony about being in uniform. So, it should have.
Shortly after, we learned that the posted speed limit on West Road was 35 miles per hour. I know in regards to learning of the 35 miles per hour, it wasn't the officer who had personal knowledge, at least did not appear that way to me. So in the event the court is not inclined to bind it over on the fleeing third degree, I would request it be bound over in fourth degree.
So third degree is just the basic, right? Fleeing and looting. Yeah. The fourth degree, or the third degree, which is higher, there has to be an accident, blah, blah, blah. Has to happen where the speed limit's 35 miles an hour or less. But they don't know. They couldn't prove which street the guy was on. And so I think that's why the prosecutor's pivoting to fourth degree, because they don't know which street he went out.
Nonetheless, I do believe, because today's probable cause testimony is sufficient as charged, but if the court is inclined not to bind over on the third degree, I would request that it would be done in the fourth degree. Okay.
Any response to that, Ms. Diallo?
In my opinion,
So the judge has to look up the statute to make sure that he's not missing something. The prosecutor, the defense attorney also has to look up the statute. It's the same difference. There's just apparently 35 mile an hour speed limit is what they were concerned with. But let's listen to Carolina's opinion.
and this prosecutor is fishing just like police do. He's trying to find some way to get this.
No, I think if he had presented it correctly, he would have had it, because driver of a motor vehicle given voice, a voice audible signal by the police acting in lawful performance of their duty, directing the driver to bring the vehicle to a stop, shall not fail to obey that direction by increasing the speed of the motor vehicle, which means starting to go, or otherwise attempting to flee or elude the officer. There you go. And it just has to be where the cop is in uniform. So the cop has to be in uniform, and if they're in a vehicle pulling you over, the vehicle has to be identified as an official police vehicle. So he failed to discuss the uniform. He failed to elicit testimony that the officer, who was apparently a sergeant at the time, was in uniform, that he was in a police uniform. So, Carolina's just, she doesn't know what she's talking about. Oh, he's just fishing. No, doesn't sound like it. It sounds like he did screw up. Carolina just wasn't smart enough to figure out how he screwed up.
This defendant.
I'm talking about with his request to fourth degree.
So, hold on, I'm pulling it up right now, Judge, so I know the third degree should have fallen, with this particular set of circumstances. I'm pulling up fourth degree right now.
What? The defense attorney with 30 years of experience doesn't know the difference between third degree and fourth degree? Weird.
But we still, how do we get past the, identification therein? You said you went after one car, and
see, she's not even actually effectively arguing. I'd be arguing if I was the defense attorney. I'd be banging the table. There's no testimony that the officer was in a uniform. We're done with testimony. So there's literally nothing in front of the court saying the officer was in uniform. They have not proven every element to the level of probable cause. And one of the elements is the officer has to be in uniform. There's no testimony to that. They fail. Easy argument to make. 30 years of experience. You'd think she'd know it. You'd think walking into the courtroom, she would know not just the charge, but also the underlying charge because of this particular situation. You'd think she'd be versed in it. No, she's not. So not a terribly exceptional performance by the defense attorney. I haven't seen anything from her that, she's still going on about, I followed the wrong vehicle. Well, congratulations. But he knew who drove away after saying stop. He knew who drove away after he said stop. He identified the person who drove away after he said stop. So you got the person who did it. You got that they did it after be giving a command to stop. You just don't have a uniformed police officer. That's what they're missing. And Carolina's not smart enough to figure that out.
then it actually was a different car. So I don't know, Judge, but the fourth degree I'm trying to pull up right now.
So essentially, it's just about the 35 miles.
Yeah, but yeah, not only that, Judge, but he didn't even have his lights and sirens on. Remember, he said
He didn't have his license. Well, so the criminal action happened before the officer got to the vehicle. She's arguing the wrong thing still. I mean, I'm not a Minnesota attorney, but reading the statute, it seems reasonable to me that she's arguing the wrong thing. Argued that he wasn't wearing a uniform.
he didn't. I heard that. Hold on. He said he didn't have his lights and sirens on for number one. But I'm gonna pull it up right now, Judge.
But see, the lights and sirens are only one thing. So the emergency light or siren is one of the things. But there is an or siren, a visual or audible signal. So the ors are important. So
To see what fourth degree looks like.
And Judge, just to
I've heard enough.
Yeah.
I'm troubled here because what you have is an officer that was called, seemingly doing the right things, going over talking to a clerk, deciding he needs to make contact with the subject, goes up, makes contact with the subject, tells the defendant, in this case, Mr. Belo, that he shouldn't leave, that he didn't want him to go anywhere. But the very essence of fleeing and eluding is that he's fleeing and eluding the statement. I'm troubled because in this case, you're right, Ms. Diallo, he did not have his lights on. He was not pursuing the vehicle he was not pursuing the suspect vehicle. He didn't know where the suspect vehicle went. For all we know, the suspect vehicle, I shouldn't interject in the record, but there's an area there where you can easily get to a 25-mile-an-hour speed zone. The officer was never in his vehicle chasing him. He thought he went elsewhere. The clerk tells him something to do that as to the fact that the defendant traveled on West Road. We don't know if he traveled on West. The officer thought he traveled on Fort. He observed the vehicle that was traveling west or eastbound on West that turned left against a no left turn signal onto northbound Fort. So we honestly don't know where he went, and the officer was not pursuing him in a vehicle. I'm not even going to bind over on fleeing elude 4. I'm going to dismiss. I'm going to dismiss fleeing elude third. However, I do believe in the face of the questions or the answers that were, hang on.
sorry,
I'm not going to change my mind.
I understand.
I do believe that there's sufficient evidence, though, to establish that the defendant committed the offense of assault, resist, and obstruct an officer.
So he still got a charge, but let's look at People versus Green. People versus Green. This is where a police officer went to a building to search for drugs. He had a warrant. A vehicle drove up. The vehicle saw him. He saw the vehicle. Defendant placed his vehicle in reverse gear and attempted to leave the scene, but the car kept stalling. Upon realizing the defendant was trying to leave, Frazier, the officer, ran right up along his car as he was backing away, told them repeatedly, "Stop, police." And the defendant in People versus Green didn't stop. The court in People versus Green, which is the 2004 case, which I'm surprised the court didn't have, and it's still valid law, hasn't been overturned. The court looked at whether or not there has to be a officer in the vehicle, and they come to the position that the fair and natural imported statute in light of the subject matter recognizes the voice of hand signal of an officer may occur in the course of duty on the street, not necessarily while the officer is driving in the official police vehicle. So it doesn't actually have to be in a vehicle to do it. So if it's a light or siren, it has to come from the police vehicle, but if he's on foot, it's fine. And so in People versus Green, where the trial court had excluded the evidence based on the officer wasn't in a vehicle, This court, the Court of Appeals, reversed and remanded. So yeah, so I'm kind of shocked. So the judge, I think, screwed up. What do I know though? I'm not a Minnesota attorney, but I don't really see any stellar performances by anybody in this.
Successful you'll be in a trial, I don't know, but I'm going to bind the defendant over.
So he still got bound over. He just got bound over on resisting, obstructing, or assaulting. Assault, resist, obstruct. So, yay.
Specifically only on count 2. Count 1 is dismissed. This is interesting. I can't say I've had this one come up, but I do think that there just isn't sufficient evidence to establish he was fleeing and eluding at that time. So
I think there is. I think the issue that the prosecutor failed on is he didn't establish that the officer was in uniform and he didn't know People versus Green. I mean, if he knew People versus Green, well, then he could make an argument at that time, People versus Green, Your Honor. You don't have to be in a police vehicle to, when you tell someone to stop, in order for it to be eluding.
I'm gonna dismiss that count. Let me just make a note here, please.
In the end, the charge of fleeing was dismissed because the officers showed no proof that he actually chased the defendant.
Yeah, that is true. That is the rationale the court gave, but I think that was wrong. So.
However, he was charged with obstruction because he did not listen to the lawful order of the police officer to remain in the parking lot. But that's not what this video was about. It was about how dumb the prosecutor was for not...
Yeah, it should have been how dumb Carolina was. Anyway, that's all I got for you today. Thanks for watching. Have a great day.